I think we're going to get started. Good morning, everybody. I'm Lee Liberman Otis. I'm the Senior VP of the Federalist Society and the Director of our Faculty Division, and I'm delighted to welcome you to day 2 of our faculty conference. We have a terrific panel on politicization of the economy, and I am just going to turn things over now to our terrific moderator, Christina Paragon-Skinner of Wharton. So over to you, Christina.
All right, thank you, Lee. Good morning, everyone. So we have an incredible panel here to discuss a couple of different facets of this broader topic of the politicization of the economy. So the theme of the panel is really meant to focus our conversation on a couple of distinct issues. So for one, what are the implications of private economic actors increasingly using their market power or public influence to play the role or substitute for the role of Congress? Do we understand this as managerialism, a response to consumer demand, something else? Second, the independent financial regulators are also increasingly pushing beyond what we might think or consider within the realm of their statutory mandate by trying to steer economic life according to a set of still politically contested values. And then third, and generally, what are the implications for separation of powers and these bedrock principles of a free market economy, free market capitalism? So our panel here probably really needs no introduction, so I will keep them pretty short. So first, we'll hear from Julia Mahoney, the John S. Battle Professor of Law at the University of Virginia School of Law. Then we'll hear from Sean Griffith, the T.J. Maloney Chair in Business Law at Fordham Law School. Then Sean will be followed by Adriana Robertson, the Donald N. Pritzker Professor of Business Law at the University of Chicago. And finally, we'll hear from Richard Epstein, the Lawrence A. Tisch Professor of Law at NYU Law School. And I, as Lee said, am your host, Christina Skinner. I'm an assistant professor at the Wharton School. So the speakers are going to offer 7 to 8 minutes of opening remarks, and then the panelists will have a chance to respond to one another. Then I'll kick it off with the Q&A section. I'll throw a couple of questions out there to the panelists, and then we'll be ready to take questions from the audience. So please do think of questions as the panelists are speaking, because we very much want this very hot topic to be a lively topic of discussion in this room here today. So without further ado, let me turn it over to Professor Mahoney for her remarks.
Thank you very much. Thanks also to the Federalist Society for hosting this panel and for inviting me to participate. The politicization of the economy has been a perennial issue, with concerns waxing and waning, levels of concern waxing and waning throughout U.S. history. Worries about oligarchy and monopoly, after all, were primary spurs for the American Revolution that led to the creation of the nation, and they were very much present in the minds of those who drafted and ratified the Constitution. Right now, the politicization of the economy is indeed a very hot topic. We are hearing a lot of worries expressed about, as well as a lot of enthusiasm for, what is often referred to as woke capitalism. I will use this term to denote, roughly speaking, the idea that for-profit private firms can, and indeed perhaps should, strive to do more than simply make money for their owners. In addition to, and perhaps at least up to a certain point, instead of seeking profits, for-profit firms ought to pursue, or so the argument goes, socially worthy goals, such as the prevention of climate change or the promotion of diversity, equity, and inclusion. The landscape, in short, has shifted markedly in a generation, because roughly a generation ago, profit-seeking firms were, with limited exceptions, assiduously apolitical. And investors and consumers did not pursue their charitable and political projects through purchases and investing, again, with some limited exceptions. They pursued their charitable and political projects through donations, either directly to those who they thought were in need or to trusted intermediaries who were not profit-seeking, at least not in the way that profit-seeking firms tend to be. But now we have a different world. Contrast that world with the world of today. What are we seeing? First, an explosive growth in socially responsible marketing claims to consumers. Many, many, many people, firms that are selling products, try to persuade consumers, buy our product and you will also do good. Fair trade, you will help people in developing nations, or green products will help save the planet. Second, we are seeing so-called ESG, environmental, social, and governance investing products. So far, these products have attracted over $2 trillion. The amount that has been entrusted to these investment products is down a little bit, but there has been enormous interest in these, particularly among the three big asset managers. Fortune magazine described it as a feeding frenzy, and even if it had lost some of its shine in 2022, ESG investing still remains a formidable and very, very important presence in the investing world. Third, we see major corporations, or a number of major corporations. A number of corporations, of course, do want to be on the political sidelines, but many do not. The largest social media companies have unabashedly supported, from time to time at least, one of the major political parties over the other. Well, one might say in response, so what? Big deal. So the landscape has shifted. What could go wrong? What are the dangers? What are the worries? What are perhaps the opportunities? It might be that the problems we are seeing are merely growing pains. Maybe we'll go into that in Q&A. But let me sketch out, in the time I have, at least some of the biggest concerns. First, looking at consumer products, where there are marketing claims made. The massive increase in environmental and other socially conscious marketing has been quickly, and to my eyes anyway, unsurprisingly followed by suspicions about their truthfulness and accuracy. And this, in turn, has led to some very interesting debates that perhaps we can say a little bit more of during the question and answer session. Very interesting debates over First Amendment and the extent to which the government can regulate the making of these socially responsible marketing claims. Another set of similar concerns arise in the context of ESG investment. Similar concerns about truthfulness and accuracy of representations. Now, the securities regulators, not surprisingly, are all over this, but it is a difficult thing, I think, for them to police claims, police so-called ESG claims, particularly as there is so much uncertainty about exactly what ESG can mean. And there are grave concerns about fiduciary duties. What are fiduciaries supposed to do on behalf of their beneficiaries? Fiduciary duty has been largely a matter of state law. We are already seeing proposals in state legislatures to clarify, some would say beef up, the state law of fiduciary duty. And of course, we see a lot of action in the area of ERISA. One might respond that if investors actually want this, if investors are willing to take on, if they understand the possibility that by pursuing ESG investments, they might realize a lower return, and it's okay with them, then why should we care? Let them do this if they're going to internalize the cost of potentially the lower return. And yet, I call your attention to the fact that a lot of the investing, a lot of the money being invested in ESG is pension and retirement money. As a society, we have made decisions about what people can and cannot do with pension and retirement funds. Those funds are supposed to support people in old age and in disability, and an enormous amount of the legal infrastructure surrounding pensions and retirement savings is designed to prevent those who are going to eventually need those savings for old age and disability, prevent them from pursuing charitable and other non-self-interested projects. So that's a whole, in my eyes anyway, something that hasn't gotten quite enough attention yet, that we want to constrain people, for example, from bailing out their relatives who run into financial trouble. And why should it be, if we are not allowing people to help out their nearest and dearest, why should it be that we will allow them to spend their retirement savings, potentially, or some of them, on various other political and charitable projects. Finally, coming to what is probably the greatest concern, is that major policy decisions, such as how to address climate change concerns, will be made not through standard democratic political processes, but will be made instead in an opaque way, without voter input and without voter accountability. Industry-wide ESG initiatives, it is feared, will in effect be a substitute for what is supposed to, for decisions that are supposed to be made through democratic processes. Now, one might respond, well, won't there be a competitor who will simply come and outcompete them? But now we come to one of the most interesting and I think important developing areas in ESG, which is the possibility that there are antitrust violations with some of these ESG initiatives, particularly the industry-wide ones. Now, legislatures, executive branch officials, and judges will all have a lot to say about this, and we are seeing movement on all these fronts. I mentioned earlier that in state legislatures there is interest in clarifying or maybe even beefing up fiduciary duties. We have certainly seen agencies acting in response to a number of these things, but there is the concern that when the government acts, the government might actually be acting in collusion with private companies, that the danger is not just that private companies will get together and through some, for example, industry-wide ESG standard, will make decisions that ought to be left to the political process, but that corporations and government will work together and in effect present the voters with a fait accompli. All right, I think I've run out of time, so I will now turn it over to Sean Griffith.
Thanks. Thanks, Julia. So as Julia says, this is, and when I think about this question, I think about it from the perspective of stakeholderism, right? The question of whether corporations should serve some interest other than shareholders, or whether there should be some alternative to the typical maximization, shareholder wealth maximization idea. As Julia says, that's a very old idea. When people talk about it, they like to refer to the 1977 magazine article by Milton Friedman, but that was just a magazine article. The debate is actually much more serious and much older than that, and goes back at least to 1932 when Adolph Burley and Merrick Dodd debated this question in the pages of the Harvard Law Review. And then there was a second round in 1972 between Henry Manne and Ralph Nader. And so my question when I hear this debate is there anything new here, or do we just need to refer our colleagues back to 1932 and 1972? And so what's the new thing? And so I think there's an argument that there's a new idea. And the new idea is it's an antitrust idea. It's the idea of the universal owner. So antitrust scholars principally came up with this notion that, look, if you look at the way that shares of corporations are held, they're held by these large mutual fund or pension fund complexes, and essentially those managers manage from the perspective of the diversified shareholder. So in the antitrust literature, that intuition leads to an argument that, well, maybe this universal owner doesn't want its portfolio companies to be super competitive with each other. So that was the insight of that literature in around 2016. But as applied to these sorts of pro-social questions, that portfolio investor perspective has gotten applied to the ESG debate. So the application there is, look, diversified investors, big portfolio investors, just as they don't want antisocial behavior in their companies either, because the antisocial behavior creates externalities that hurts their other investments, or more broadly, their other commitments. So applying this to corporate law, corporate managers ought to adopt the universal owner perspective and take pro-social investments into account. And that leads to a certain set of arguments about ESG, about DEI, about whatever. My argument is that is wrong. It's incoherent on its own terms, and it's impossible. It rests upon an impossibility. So here's my claim. That portfolio theory argument, at least as applied to corporate law, can't work, because not all portfolios are identical. It would be one thing if everyone held exactly the same thing and exactly the same weight and concentration, and then we could sort of think about maybe a trade-off to this company here affects this company here. But every portfolio is different. Even the S&P 500 is not an evenly weighted portfolio of 500 companies, but is essentially a large cap technology and pharmaceutical company index. So when portfolios differ, there is no single unitary portfolio perspective. And if there is no single unified portfolio perspective, the weights of those holdings in those different portfolios create intra-portfolio conflict that cannot be resolved simply. So claim number one, the theory doesn't work because there is no such thing as a portfolio perspective. There are many perspectives within every portfolio. But that might sound like fighting the hypothetical, right? Because what the real argument here is that, well, we're all diversified shareholders. Even if we don't hold the same investment portfolio, we have diversified portfolio, and we at least have social concerns. So the second level of the critique is, well, you know, even if that's true, there are still pro-social investments that every person would want companies to make. And they would go so far as to argue that, well, we would want companies in some circumstances to make an intervention that harms the company to benefit either the rest of the portfolio or the rest of society. So assume a policy intervention at Exxon, for example, that might harm Exxon, but that would benefit other companies in a portfolio. My claim is that trying to balance the interests in that kind of argument is impossible. It's impossible because of the knowledge problem. In order to understand the costs and benefits and the trade-offs involved in that kind of a calculation, somebody would have to know the costs and benefits of the policy intervention at Exxon, and I submit that really only the Exxon managers know that. They would have to know the costs and benefits of that same policy intervention across all the rest of the companies in the portfolio, and I don't think people that know that advise ESG investors. I think that nobody knows that, but if anyone did know that, they would run a hedge fund for a little while and then retire to a yacht in the Mediterranean. So nobody knows that. And then the third thing is the effect of adaptation. So once there's a policy intervention at one of these companies, it's not a one-round game. There are adaptations. So that company and every other company in the portfolio does something differently as a result of the policy intervention, and it turns out it just doesn't work. So that's the law of unintended consequences, and there are millions and millions of examples of that. One is that the EU rules on biodiesel fuels. So the EU passed this rule that they didn't want as many petroleum products in their fuel products, and so they forced companies to sell biodiesel, which resulted in deforestation in South America when lots of land was turned over to raising those crops. So it doesn't work. Basically, the portfolio idea, the idea that we should manage for portfolios, not for the simple idea of shareholder wealth maximization, does not work. And if that idea doesn't work, it turns out that we're just thrown back on the old debate, and there's really nothing new. There's nothing new here at all.
Awesome. So I think I agree with everything that has gone before.
That's dangerous.
I know, but it's okay. Richard's here to disagree later. So look, I mean, I think fundamentally, no, I'm pretty sure it's on. You guys can hear me, yeah. Fundamentally, I think what we've heard so far is that there's just a tremendous amount of confusion in this entire conversation, right? There's lots and lots of angst on both sides, right? Both on the sides of the woke capitalist brigade that, you know, wants to use this to save the world, and there's also, I think it's fair to say, an awful lot of angst on the other side of the anti-ESG, like, oh my God, you know, it's going to eat the world, this is terrible, it's the end of capitalism as we know it. I think, you know, the best way, I'm just going to, you know, act like a law professor and say, I just want to lay out what I think is really going on here, and then we can try to have a clearer conversation without quite so much confusion about what we're really talking about, right? So Julia already sort of started this, I think, much more eloquently than I can, laying out the differences. Right? We've got the issuer level questions around ESG. This is the question around what should a manager do? Should a manager consider DEI? Should a manager consider the environment? How is an individual company, right, that's profit maximizing, at least in principle, it's a for-profit company, how is it supposed to consider these trade-offs, right? That's the issuer level ESG. And then we've got the investment level ESG. This is in the context of what's a pension fund supposed to do? What's BlackRock supposed to do? What's Vanguard supposed to do, right? Those are actually different questions. They're different bodies of law that regulate them, and I think we have different concerns that we need to bring. And so often, there's just a ton of confusion, right, at just that pretty basic level. So I'll just tell you, maybe I'm like very kind of laissez-faire. You can see my sort of pro-market orientation coming out here. It's a market. Right? If you don't like what a manager is doing for a company, generally speaking, you don't have to buy it, right? You can sell, right? So if you think that Elon Musk's vision of Tesla and how it should go about making changes in the world is bad, like, don't invest in it. If you think it's good, you should buy it, right? We have lots of companies that do lots of different things. Unless you're somehow constrained to owning it or not, right? Like, I guess I'm just not all that worried about it. I do think, though, as has already come up, right, there's an interesting question about corporate law here. Right? Is this just managerialism in another bottle? Is saying that, well, we're going to let Elon Musk or JP Morgan or pick your favorite CEO, we're going to let him or her substitute his or her decisions, right, beliefs about what's good for the market, and we're going to let them take investor capital and deploy it to those ends. Right? That is a question of corporate law. I think it's a really interesting question. I thought, it was really interesting. I thought that the debate about managerialism was over and it had been won by the sort of shareholder primacy folks. I thought like Lucian had kind of declared victory. It seems like this fight has just come back in another form. So I think, going back to Sean's statement, I don't know that there's a whole lot new here. This is just sort of old wine in new bottles. It's an interesting question, but I think we know how to think about that question because it's really just the same fight from the 80s come back. Then we think about the investor level. So now what we're talking about are mutual funds or investment companies that are geared towards ESG, whatever that means. And again, there's a whole other kettle of fish about the confusion about what even is ESG. Like, is Tesla a green company? Well, on the one hand, they make electric cars, and that's good because it doesn't burn carbon. On the other hand, the way they build their batteries involves a whole lot of awful environmental damage. And then there's also all of the social issues around, like, I don't know, do they treat their employees well? Maybe, right? So even just deciding if a particular portfolio company is ESG or not, right? Whole other problem. Once we, though, go to this investor level, I think it's really important to keep in mind another level of the confusion, which is what I think of as the value-based and the values-based, right? This is something sometimes known as, collateral benefit ESG versus risk-return ESG. So, look, I mean, if you believe that there is a transition happening towards green technologies. Like, I don't know if that's true or not. Lots of people have lots of different investing theses. If that's your investing thesis, then it is profitable for you to substitute towards less carbon-intensive production. If it's not your investing thesis, then you probably shouldn't do it. But again, I'm old-fashioned, I kind of believe in markets, right? Lots of people have lots of investing theses. There's all sorts of actively managed portfolios out there that I don't necessarily subscribe to. Doesn't mean that other people don't, right? And can't in good faith think that this is a good idea, right? So the value-based ESG is the idea that this is just good for my returns, right? Maybe the reason a particular portfolio company is engaged in these socially responsible marketing claims, as Julia put it, which I completely agree with, is because that's marketing, and guess what? There's a reason companies have marketing budgets. It's because they make money by, making their customers happy, right? So if your investing thesis is, well, doing all these things is going to make my customers happy, and then by happy customers, I'm going to have higher revenues, which means I'm going to have higher profits, that's not a crazy idea. Maybe I don't have the same investing thesis, but that's okay. Right? Different people can have different investing theses. There is, on the other hand, this values-based ESG, right? And this is the idea that, no, this is actually bad for my bottom line, right? I am willing to give up some return or take on some extra risk, right, in order to pursue this social goal. That is effectively engaging in charity, right? That's saying, look, I'm willing to take money out of my pocket. Right? That, I completely agree. When I worry about the fiduciary angle, when it comes to pension funds and 401ks and 403bs, that's the part that we need to be worried about, right? And Rob Sitkoff and Max Schatzenbach have written about this. This is the part that we need to be worried about. And I think the confusion, part of the confusion that we're seeing is the slipperiness between the value-based and the values-based ESG, right? Because so often you hear this doing well by doing good. And I don't want to totally poo-poo that, because I do think marketing is valuable. Right? And if all you think ESG is marketing, like, not all marketing is wasteful. There's that old joke, half of my marketing budget is wasted if only I knew which half, right? So maybe these people have found the half that's worth doing. And it's a market. Do what you will with that. I want to point out one other element of ESG, which, again, this is all part of the confusion. There's the portfolio selection side, which is pick the companies that are good or don't pick the companies that are bad. But then there's also the voting side, and that's something that I think I want to bring into the conversation here. This is the idea that somebody like, say, a BlackRock or a Vanguard or some other large asset manager might vote their shares in a way that is consistent with their values. And this gets to what Sean was talking about. I think a lot of the universal owner conversation comes on the voting side, right? It's not on the portfolio selection side, it's on the voting side. Again, one answer to this question is, well, it's a market, right? First of all, I think we can have a long conversation about how effective shareholder voting actually is. I think it's very interesting that all of a sudden the same folks that think that there isn't really a shareholder democracy have become like rah-rah on ESG voting. There's a little bit of a tension there. Most of these votes, they're precatory, can't really do much with them. Unclear how much of that isn't just marketing at the level of the portfolio manager. So where do I guess, kind of come out in these opening remarks? For the most part, I guess I come out kind of agnostic. Like, I don't know, it's a market. Buy it, don't buy it, do it, don't do it. Ultimately, I guess I'm still old-fashioned enough to think that whatever's more successful is going to win out in the market. Now, there is a big asterisk here in everything I've said, which is that sometimes people don't actually have free choice, right? And markets don't function when people can't actually make choices. And this is where the pension fund stuff comes in, right? So if I am constrained by my employer to invest in one of the following 5 funds or 10 funds or whatever it is, all offered by the same portfolio manager that has the same voting strategy, right? Now we're in trouble, right? Because now I can't easily move my capital to a different portfolio manager who has a different voting strategy. Right? So there are places where I guess I'm not like totally Pollyanna-ish or totally, Panglossy and everything's for the best in the best of all possible worlds, but the places where at least I would submit to you that we want to be worried in these conversations, it's not an across-the-board worry, right? It's very particularized concerns in places where we have reason to believe that the market won't deal with this on its own.
All right. Now, I'd like to disagree with people, but I'm not sure that I do. So what I'll do is I'll try to say the way in which I think this problem ought to be organized. What you do is you have the following 2 phenomena that you have to deal with. One is you have an array of individuals who have very different preferences and very different views about how the world is and how it is organized. They have different views on the proper employment relationships, different views on whether you have unions, different views on whether or not global warming is something to happen, and 2, if it's happened, whether it's going to be a positive or a negative sorts of things and so forth. You have all sorts of issues in which there is, just to put it in the simplest fashion, a very powerful difference between people who attend meetings of the Federalist Society and people who attend the meetings of the American Constitution Society. And so then the question is, what do you think about the world as the variance starts to increase? And I think, just taking a leaf from what Ariana said, is the higher degree of variance that you have, the stronger the argument is to make sure that the preferences that one person exhibits are partable from the preferences that somebody else can exhibit. And so what can happen is you would then start to think, at least in the market terms, of somebody comes forward and says, I have an ESG program that I'm going to put forward. And if you do it as part of an initial offering, and it turns out that it has some sacrifice with respect to rates of return, the people who join that essentially have decided to make a part investment and a part charity. But then you could have the other things. You could have the greed fund. And what the greed fund says is I will only invest in those things that essentially are going to do well by me. And you could call me the anti-ESG program. And I think it's perfectly okay that people would start to invest in funds like that or in anywhere in between. And indeed, I think it's perfectly permissible for individuals to say, I don't know which of these two things I believe in, so I'll buy Fund A for one purpose and Fund B for another purpose, and I will create a diverse portfolio at the individual level by selecting things at different ways at different points. So all of a sudden, this looks to be very nice, but it turns out there's a fly in the very powerful ointment, which is we certainly don't believe that free choice in a world of high variance is going to be true with respect to everything that we're dealing with. So forget about corporations for a second. Just assume you had two individuals. It turns out that I have a high preference for manufacturing with very toxic substances that are going to end on your lawn or inside your lungs. And what happens is we say, no, 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 that's a tort situation. And so what we have to do is to engage in legal activities that will control the externalities that otherwise will exist and create negative social welfare. And so when you start looking, for example, at something like global warming, the reason why the complications start to arise is there is one group out there who believes, in effect, that if we do not take prompt action to switch to, for example, an electric car basis and so forth, there'll be calamitous consequences. And so if they were right, I think the things would be very comfortable. But there's another group out there in which I put myself as a member, which says if you actually do try to make a radical shift away from fossil fuels to these rather exotic technologies, what you will do, in effect, is you will find that these exotic technologies can't work without the fossil fuels that you're banning, and the whole system will fail. The problem here is when you have to make that kind of an existential choice, you can't sort the world into those people who want to do one thing and those people who want to do the other. What you're having somebody claim is that your activities are nuisance-like activities that are going to harm everybody. And what makes the problem so very difficult today is that we see that the claim is made by both sides against the other. And when you see to that, what you have to do is to find some neutral forum in which you could try to resolve these sorts of cases. And when I start looking around, and for example, on the fossil fuel sorts of issues, I don't find too many people whom I would regard as being reliable, neutral arbitrators on this particular subject. It turns out that there are a lot of very strong preferences on both sides, some of which are benevolent, some of which are not, all of which are very difficult to disentangle. So I think that in some sense, the ESG problem, if you put it as a macro level, is a problem which we cannot solve by market mechanisms, because we all agree that we're opposed to externalities that harm other people and their physical well-being, and each of us is accusing the other person of doing this sort of thing. And we do not have the kind of simple push-pull relationships when somebody runs you over with a Mack truck that we know who is the aggressor and who is not. So we find ourselves into this particular kind of situation. Now, that's the global warming situation and why it's so difficult. I happen to have a very strong view on that. I think most of the people who are in favor of severe limitation on fossil fuels, it's an open invitation to disaster. And in the public debate, I think, in effect, if you start looking at the brownouts, the blackouts, and the distortions that are taking place, that their position is not sustainable. I also think what happens is that in many cases, when they start to do this stuff, what they do is they attributable to the increase in carbon dioxide, things that are attributable to other sorts of things, namely terrible management of natural resources. So if you look at the incidence of forest fires, it was an utter disaster at the beginning of the 20th century. It improved incredibly markedly by mid-20th century. And recently it's gone up quite ferociously. And most of that is not attributable, it seems to me, to changes in natural events, but to the way in which, quite literally, we teach dead wood in forests by allowing these things to fester and create genuine environmental danger. So I'm going to push quite hard on that. The second part of ESG, in terms of sort of internal firm management, I take a rather different kind of view. I do not think there's any reason to make collective decisions as to how you run your firm. I take the following view, that stakeholder democracy is a terrible mistake because you cannot be a fiduciary, going back to what Julia says, to two people who have interests which are utterly antithetical to one another. And so what you have to do is to say that each group, which is homogenous, has its own trustees, and then what they do is they negotiate in the market with each other. The question as to whether or not you could keep this competitive or whether it becomes monopolistic is going to be a fierce problem that you have. But if somebody's going to start to say, we expect firms to be shareholders and take into account the interests of everybody else, it's quite literally any solution is permissible because there's no way that you could figure out what's going on. So I have a proposal of my own. I think the persons who ought to believe in a stakeholder economy ought to be labor unions, so that when they start to negotiate with management, what they do is they take into account the welfare of the shareholders, they take into account the welfare of the customers. They're absolutely frightened about having any disruption of services through strikes because what it does to incidentals other people. And you know that a position is an intellectual phony if the only way that you're going to support it is say, you guys believe in a stakeholder economy, we're going to be egotistical in exactly the same way that we've always been, because we can't conceive of how you run a labor union if the only people you don't care about are your members. And so I think at that particular point, we do this. Then it comes to the governance question, as how do you organize this? And here, too, I think we have this problem. I think, in effect, that when firms organize themselves, they should be free to choose what they want. I think they have to commit themselves by charter. I'm very opposed to a situation where you get money in under one set of terms and then have an about face for a different system, because I think it's fraud on the original investors to do all that stuff. And it turns out that if you want to have certain kinds of benevolent policies, by all means have them, and then let other people decide. So on the question of internal sort of labor relations and so forth, basically where Adriana is, where I think Sean is. Matter of fact, I don't think there's any disagreement amongst us about all of this. What we are worried about is somebody who comes along and says, you know, Professor Epstein, you're a real nitwit. You believe in the contracted will. You said that for 30 years. We now know that this is just simple-minded copyright, and that what happens is we're going to impose upon every firm a duty that they can only dismiss employees if they give them a full hearing before it turns out it's done, and they have to agree to pay certain kinds of very heavy damages if it turns out it's wrong. And so at that particular point, what the ESG is on governance is it's just outright coercion from beyond the particular system telling you how to work. Now, there are some firms that, by the way, can work quite well with grievance procedures for employees, but you try running a tech firm on that basis, and you discover that by the time you've gone through your fourth set of employees with various kinds of situations, and you try to go to the market, the only thing that you can now advertise is you have 72 claims against you up to $1 million, which will have priority over the return of your particular investment. So essentially what you've done in a tech business to take that model is you've destroyed the way in which the firm is run. And so if you're going to have to figure this out, and I'll just end on this note, to talk about a firm as if all firms are identical in terms of their internal constitution is absolute madness. The rate of turnover with respect to employees, the age of the employees, the kinds of tasks that they're going to take out, their median salary, and all the rest of that stuff. There is such a massive amount of heterogeneity with respect to this, that sort of taking one of these sort of four-cause dismissal situations, mandatory union situation, various kinds of termination limitations and so forth, that's an invitation to suicide. And so just to sum this all up, when you start to deal with the definition of an externality, you're going to have a public debate and resolve it. But on some of these other issues having to do with the internal operation of the firm, it seems to me the sound view is to reject all the stakeholder situations and to reject all efforts on the part of government to impose uniform terms on the grounds that ESG knows so much better than I do about how to run my own business that I ought to genuflect to them and thank them from saving me from my own judgment, which of course is vastly inferior to theirs.
All right, well, thank you to each of the panelists for a really excellent set of remarks that have so elegantly fleshed out the very many issues surrounding the politicization of the economy. And I think one thing that we've heard for certain is that ESG is essentially the driving force behind the politicization of the economy, which is why we've had the remarks so focused on that space. Now, I have a number of questions to invite the panelists to elaborate a bit further on their views. But before I do that, I want to ask if anyone would like to respond to the comments that were made amongst each other yet. Sean?
Well, just to try to make some disagreement, I want to respond to something Adriana said, and I want to argue that. So Adriana picked up this distinction between value-based and values-based ESG, and I want to say that's just fighting the hypothetical, and it's not a real distinction. If ESG was value-based, we would not have to talk about it because corporate managers would be climbing over themselves to make that change. If green energy investing was good for Exxon, the first person in line to do green energy investing would be the CEO of Exxon. So that's not a real thing, right? Because managers in a competitive market are trying to make investments to maximize return. And if ESG maximizes return, they're already doing it, right? So the only kind of ESG that there can be is the other kind, which is the trade-off kind. And I do agree with that. A lot of this is about voting, and maybe we'll talk about that later, but I just want to say that the distinction between value-based and values-based ESG is just a way of fighting the hypothetical.
Wait, can I?
So, yeah, can I?
Adriana gets to respond.
Yeah, so, I mean, a couple of things. First of all, I'm going to fight you back on that because, like, they are doing it, right? So, I mean, I guess my response to your claim that if it were profit maximizing, they would be doing it is to, like, hand you the list of all the companies that are doing it and say, look, they're doing it, right? So, now, I don't know if it's going to work out. Maybe it's a terrible idea, but nobody knows the future. All we can do is make forecasts based on the best available information, and some things will pan out and some things won't, and we'll see, right? But the idea that it can't possibly be a good idea strikes me as, like, strange way for, I mean, look, I certainly don't have that much confidence in my forecasts to say that I know exactly what's going to happen, right? I'll tell you a funny story. I was chatting with somebody who works at the Norwegian pension fund as an investor, and it was on an ESG topic, and, you know, I asked her, I said, oh, so, like, you guys, you know, I know you European pension funds, and you're Northern European even more so, you're all in on this, like, ESG energy transition stuff. And she said, yeah, you know, it's a really important part of our investing thesis. And I said, I just make sure I got this right. You guys are also known as the Norwegian Oil Fund, right? And she said, yes, that's right. And I said, right. So the Norwegian pension fund is investing oil wealth pulled out of, like, the ocean. And I said to her, are you guys still pumping? And she said, of course. And I said, so it's a hedge? And she said,
Yes.
right? Like, it's not crazy if your revenue comes from pulling oil out of the ground to say, well, gosh, I don't know, maybe something's going to change in the future. It might be a good idea to also have some investments in batteries.
But
right?
look, I disagree with this.
Why is that such a bad idea? You don't believe in diversification?
No, let me tell you what I think is wrong with what you've said.
Okay.
Apart from what is
Pretty
right from
sure
what
that
you
this
said.
is true.
The question is, when you start considering these alternatives, are you considering them because you want to diversify, given the fact that you believe that energy source that I'm predominantly interested in may not be the only one? That's fine. But there's another thesis, which is I'm going to start doing some of this stuff because if I don't do it, I know the regulators are going to make me do it. And what this is a strategy essentially designed to anticipate and to blunt the degree of regulation that's coming. And that, in effect, is a situation which indicates that the threat of regulation has at least some of the consequences associated with the operation. So unless you know, when they're doing this diversification, whether this is a defensive rear guard action against the regulators coming in, you don't know whether it's bona fide situations or not. So
Wait a minute. How is it not also profit maximizing for me to reduce my political risk?
Well, I'm just saying it is, but it turns out it's profit maximizing subject to the constraint. Sure. But the issue we're trying to figure out is whether or not we want that constraint to be there. And if it turns out we don't want that constraint to be there, which is what I'm arguing about, the issue is that the regulator has created social losses even if he has yet to implement the program. That, I think, is what's going on. So let me sort of give you an illustration. Right now, you have to go through the FTC, and it turns out that they're under this Meshuggah kick, I mean, that's a technical term, in which my colleague Eric Posner, I mean, is the most febrile member, sort of indicating that the antitrust law, as it applies to labor relations, is such that this is a major kind of problem. And there's also other groups out there which are saying the weakness of unions is the problem. So what happens is I want to go through a merger, and I have to persuade the FTC I'm going to do it. So what I do is I agree to a program which says I will not oppose unionization that takes place within my plant. The workers are free to decide. That's not because I believe this is a good idea. It's because it's the only way I think I could get past these kinds of regulators. And this is absolutely routine right now before the FTC, because everybody knows that they're coming after you on both the antitrust side and so forth. Or you want to get a merger through, and now you look at these characters, and they have announced that all covenants not to compete, which have been governed by a rule of reason for the mere 300 past years and so forth. Lena Khan is smarter than everybody else, in case you didn't know it. So this nitwit, she comes forward, and what she announces that these things are per se illegal. And then you say, well, what are you going to start doing about investment and training? What are you going to do about trade secrets and all that stuff? And it turns out, they say, well, we still have to worry about these McDonald's workers. So if you're starting to face with that kind of an environment, you will make all sorts of choices that are profit maximizing, subject to the condition. But I think what we're more interested in is whether it's legitimate for the state to pose the condition on top of you, rather than for you to figure out how it is that you wiggle at the end of the hook and try to minimize the particular harm. Mitigation in the face of threat and regulation is not optimal behavior. It's optimal behavior only on a conditional sense. So that's where I think the disagreement.
So I don't actually, can I just say, I think we actually are in agreement.
Oh, yes. Arm in arm, we face the world.
Because I think what you're saying is, well, gosh, it would be better if like government were more rational. But given the world that companies face, they have to do all sorts of things that like in a Panglossian world they wouldn't do. But
not Panglossian world, in a competitive market.
Well,
there's no Pangloss.
Hang on, you're objecting to government intervention, right?
In telling people how, government regulation telling you how to organize your internal workforce.
Right. But subject to whatever rules they face, I think we're in agreement that it's not crazy to say, well, look, I'm going to manage that risk. I would prefer not to have the risk. But in a world where I do,
I agree with that.
I think what you're then saying is maybe, just to make sure we understand, your objection is not so much to, at least if we frame ESG as being in this particular context of, say, labor relations, taking defensive actions around potential future behavior by regulators. It's not the defensive action per se you object to, it's the interventions that are leading to that defensive action.
Look, there are two things. In an unregulated world, we have to decide whether or not we're going to invest in batteries or whether we're going to invest in oil and gas. And we want to hedge our bets. But if it turns out that the reason we hedge our bets is we are worried about the possibility that somebody will limit our oil and gas output and require us to go into batteries, we're better off doing it voluntarily now than being forced to do it under more disadvantageous terms. And that is what the pattern of American business turns out to be. And so the thing to understand, particularly if you're a diversified company subject to multiple forms of regulation, this kind of coercion really works. Because there's no particular point where it's worth your interest to jeopardize the large business by fighting the small regulation. So the only guys that will do this are small firms, highly specialized in a given technology that's about to be wiped out, and they will go to the mat against the people on the other side. But my experience, having worked for many large corporations over the years as a consultant, I will name none of the cowards that I work for, is that every single one of them essentially is living in the world that I describe, which means that they cannot take public positions that have a great deal of intellectual clarity. Because the moment they start to do that, they're going to expose themselves to collateral threats from any one of the 15 agencies that start to regulate the way in which their behavior works. So I think it's important to understand that the threat potential of regulation coming through alters market behavior from the very, very beginning, and the diversification strategies in response to those threats are not socially optimal, they're only conditionally optimal. That's all I wanted to say. And when you started this discussion, I didn't hear that distinction, but I assume that as a wise and prudent woman, you agree.
I agree with you.
Excellent conclusion to this debate. All right, so I'm going to pass the football over to Professor Mahoney. Did you want to weigh in on this?
Just one clarifying point. I don't think anyone will disagree with me, although go ahead, please, fellow panelists. The political aspect of things with the Norwegian Sovereign Wealth Fund, CalPERS, and so forth, there is a grave, grave concern that they will continue to allot money for reasons other than value, right? And that the ESG and other sustainability initiatives will give them cover. So when I look at the Norwegian Sovereign Wealth Fund, I too am wondering, is it a hedge? Is it ideological capture?
It might be some mixture. When I look at CalPERS, I think, whoa, this is a real opportunity to make what was already disturbingly opaque even more so.
Yeah, and what happens, of course, is CalPERS is big enough to set up 2 internal firms. The junkie firm for people who want to believe in the ESG, and the market firm that those that don't. And then if you watch the way the cash flows will go, this is the prediction. At the beginning, there'll be a respectable amount going into the ESG side, and then as the returns start to falter, what will happen is the money will shift over to the other side. And that's exactly what you want. We're not against charity, but essentially once its true cost becomes revealed, people can decide, I'd rather invest, this is Milton Friedman again, maximize return, and then what I do is I increase my charitable contributions privately by virtue of the fact that I have more wealth, and I don't tie the two things together, because generally tied investments are wasted investments.
That's taken a bit of a beating with the Sam Bankman-Fried thing.
Oh, my good friend? I mean, what's taken a beating? Sam?
Just that idea that, yeah, I'm sorry.
Oh, you mean the
It was
fact
just
that
a
he
joke.
gives all the money away to the democratic charities? Yeah, well,
It's just a joke that didn't land.
he's going to have
Okay.
to grow up.
All right.
He's
I'll just
going to
ask
grow
those
up in
questions.
jail, unfortunately.
All right. So let me ask you, Professor Griffith, a kind of open-ended question. So I think what we're hearing from all of the panelists is not only that the term itself, ESG, is confusing and mushy and intentionally so, but also the problems that arise from ESG are multiple and multifaceted, and it creates a lot of confusion, as you were saying, Adriana, right? So we've got issues of fiduciary duties, right? We have concerns about greenwashing and consumer protection, right? Concerns about opacity, which can reduce the ability to make choice or exercise market discipline. So maybe I can ask you, for those who are objecting to ESG, what should they do about it, especially because so many of these ESG initiatives are not going through formal channels of law, right? They're happening sort of in backdoors and through managerial preferences. So what should we do?
Well, I guess states are starting to try to do stuff about it, and their state legislatures are doing it in the sometimes I think not the optimal way. But I'll answer this question, but I want to answer it by going back to something that Adriana said also. So Adriana said a lot of this debate, because it's been occasioned by these intermediaries, is focused on the voting. And in some of this colloquy that we just had, if you have, CalPERS is influential because they're able to go to management of corporations and say, we have, a gazillion shares, and if you don't do what we say, we're going to vote with the opposition in the next election of directors, or we're going to go along with some other proxy contest. And this obviously is something that happened at Exxon. Right? That's why I'm using Exxon as my example. Right? There was a proxy contest run on the basis partially of these kinds of issues, which was supported by a lot of these large institutional intermediary asset managers. And so something that Adriana said is like, look, if you're going to invest in, Adriana's theme of her comments was markets are great and markets will solve this. And if you want to invest in an ESG fund, you can do that. And I agree with that. Like if you want to invest in any kind of whatever actively managed ESG fund, you should do that. But one thing that happens at these fund complexes is that they have active funds and they have passive funds. So the passive funds are what we all go in our 401ks. The passive funds are the 500 indexes, things like that. And they hold the vast majority of the assets under management of these firms. And then they have the active funds, which, are in and out of stocks, and they have strategies. The problem with voting is that these giant investment complexes vote the passive votes too. Right? So if you have an ESG strategy in your active fund, that's great. Vote your active fund for your ESG strategy. But you can't, if you're an asset manager, then take your passive votes that you have, all these retirees and so on, and vote those along with your ESG strategy. There needs to be a different strategy for how you vote those shares. And unfortunately, though, there isn't, right? A lot of these firms just use their leverage.
It's a flat-out breach of fiduciary duty.
I think so.
So wait a minute, but we're moving towards, BlackRock's moving towards voting choice. I think this was a real problem for like 10 seconds, and I think it's now getting resolved by the market.
But does that resolve it? It's hard for, how many people understand it? How many people actually are set up to do the necessary administrative stuff to take advantage of this opportunity that BlackRock is giving them?
So I think everything's going to come down to, and so just to make clear what's going on here, when you invest in a mutual fund, you don't actually own the shares in the portfolio companies. Sorry, this is like investment companies 101. The pool, like the manager votes them on your behalf, and the manager has fiduciary duties with respect to that voting, right? But of course, people might disagree. They might, especially when we're thinking about, ESG type stuff. But honestly, the G, and I just want to take a plug here, the G in ESG means governance, which is also like boring old corporate governance, staggered boards, chairman, CEO being separate people, all that good stuff. And so, if you split it out and you let the portfolio, or you let the investors actually vote or tell the portfolio manager how they would like their sort of proportional share of the portfolio voted, then you kind of break this concern that Sean is articulating. But of course, I think everything's going to come down to what the default is. So if the default in the event that you don't tell BlackRock or Vanguard how you want your shares voted is, well, we're just going to follow our main strategy, then it may not make any difference. If the default is, we don't cast the vote at all unless you tell us what you want, well, that might create all sorts of other problems on the other end, right? You're going to end up with all sorts of frozen charters and the types of things that Scott Hurst has written about. So, it's actually, I think, a really interesting design problem. And I don't know that we have the perfect solution yet, but I do just want to say that this problem of, BlackRock has one voting rule that it uses for everyone. First of all, that's already not true. They have different voting guidelines for different funds. But we're also just moving further and further away from that as we move along. So, I think that this is great. Maybe all the attention to this problem is what spurred the market to come up with types of solutions to this, right? But I think, I don't want to overstate, or I think it's important to not overstate the extent of the problem going forward.
Look, I do think there is a serious problem here in the following way. What Adriana said is clearly correct. If you say you have a duty to vote and we won't cast your shares if you don't vote, lots of people won't vote, and so what you're going to do is have a huge absentee base. Well, then the question is which way you ought to set the default. Yeah. And I think at this particular point, Uncle Milty beats the left. What you do is you set the default in favor of the notion that people are going to separate their charitable activities from their market activities, and that basically you go into a non-ESG firm unless somebody affirmatively indicates that they want to make a charitable donation. I think that's the correct way in which to do it. And my view is if I put that to Mr. Fink, who runs BlackRock, I think he would probably take a dissent to it. But I gather the internal opposition inside that company is such that he's being forced to at least backtrack to some extent. And then I'll just ask the rest of you, if we agree that you have to have a default provision, I think it has to be back to Milton Friedman's 1970 article.
I have a question, though. Do you think that there should be any distinction made with
What?
Should there be a distinction made with the retirement funds? You're talking as if it's a no-brainer.
No, I think with the retirement fund, I think I have more confidence in the default rule, and I'm highly likely to believe that it's not going to be upset. But I think with respect to non-retirement rules, I would still have the same default rule, but the prediction would be that there might be more slippages. Again, my prediction is you'll start out with some slippage, and then after time, what you will find is the amount of slippage will start to fail. And I think markets actually become much more legitimate in the traditional Friedman-like sense if the alternative is freely available and fully rejected, rather than somebody saying, well, the reason this stuff never worked is because we were never allowed to try it, given all the management rules. And so, yes, I do think that there is a distinction, and my guess is you'll find virtually nobody in the retirement situation who's going to be charitable in that way. They have to worry about their children, their church, and a lot of other things. And the problem about doing charity through an ESG fund is you have no idea who the hell the beneficiary is going to be. And that's not the way most people give charity. They give it to designated beneficiaries, and the ESG fund just doesn't have that thing. So my guess is that what you're saying is absolutely right. And I think, in effect, that's just another reason why this is a bad charitable model, right? I mean, how many people give charity? Oh, well, I'm going to give money. There are 1,000 charities out there. What I'm going to do is I'm going to put $100,000 into charity, and I'm going to spin a wheel, and then we will decide which of these charities get what fraction of that money. Is not the way in which charities work. Charities work on relationships and identities. They don't work on this other stuff. I've got to shut my phone off because my wife disagrees with me.
Well, while you do that, let me chime in on the default question, because I wrote a paper about plug for my paper in the Texas Law Review answering that question. But I think that there's a real problem with if we return. So Adriana's point is that my paper's moot now because they're moving through pass-through voting.
They took your advice.
Right. Oh yeah, that's what it was. That's what it was. And so the question is if the vote is returned to shareholders, or at least in this context, what happens? And I think I'm going to go back to Henry Manne. And Henry Manne says, look, votes are not super valuable most of the time. They're only valuable when the prospect of the selling the share is not valuable, or right, where it gets to the point where no one wants to sell anymore. They're sort of like substitutes. And so the trouble with voting is that when things are going great at Tesla or whatever, pick your paradigmatic woke corporation, that woke corporation, when things are going great, you might be okay going along with it because things are going great. And you're not thinking, I'm going to sell out of this firm because I don't like the fact that they pay lip service to the X issue. So here's, I think, the answer to this. It's to get red states to vote their shares. And to get red states to vote, not just to vote in like the 14A8 shareholder proposals, but to get red states to vote their pension fund shares to elect what I would call a Friedman director. So to run a short slate proxy access proposal, and then red states band together, Texas, Louisiana, Florida, et cetera.
They're doing it,
right? And then I don't know that they're doing this. I'm trying to talk them into it, actually. and then they run someone who's a Friedman director, and what does the Friedman director do? He goes in and he says, listen, I want to know all the ESG, non-shareholder wealth maximizing programs that we have going on at the firm, and I want a wealth maximizing justification for them, or I want them to be on the chopping block. I think one of these programs, I think an election like that could work, and I think it could have effect inside the firm, but I think the fact that states were willing to do it would also have a terrific in terrorem effect, where firms do not want these kinds of flamethrowers inside the boardroom. Firms do not want boardroom disruption around these kinds of issues, and that, I think, is the perfect way to calm down all of the madness around these sorts of questions.
Can I ask one simple question? Why does it seem to be against the laws of nature, nature's God, for Democrats to oppose ESG? I mean, you said you wanted red states to do this. Is this an implicit statement that no blue state attorney general is prepared to take that view? That's what I hear you as saying, and I think I'm probably right, but I would like to have it from the horse's mouth.
Well, I mean, it seems like that to me. I mean, I would like it if it were not true. It seems to me that ESG is not good for any. I don't know why it's good.
Yeah, that's right. New York State
Even
really
with
needs it.
antitrust, even with the antitrust considerations coming up, with state AGs showing a lot of interest. And the most recent revisions to the antitrust laws are thought, at least at this point, preliminarily, to perhaps empower state AGs, make them an even bigger player. And that would include ESG.
Well, and notwithstanding your views on, or your other views on the current chair of the FTC, she
Your
has
views
also.
too, by the way.
I will reserve any statements because I knew her in law school. She has actually come out and said ESG is not a defense against otherwise anti-competitive behavior.
Yes.
So even the current administration has come out and said that. So this is good news.
But as a defense against anti-competitive behavior, but she didn't say it is an offense against competitive
Well,
markets.
baby steps, Richard.
Baby steps by babies, okay.
Okay, well, that's great. I mean, I wanted to ask the panelists to talk about this interesting ESG federalism development, which I think we've covered pretty well now. It's certainly something to watch, as you all have said. So I have one more question for the panel, and then we'll open it up to all of you. So if you want to start forming the queue, that would be great. So I want to shift gears a little bit and ask everyone what they think about the courts, right? We've been focusing on the private sector a lot, but we haven't really spoken about what's happening with the independent financial regulators and the role of the courts, especially the Supreme Court, which seems to have at least some burgeoning appetite for reining in regulators replacing their judgment for Congress along this popular narrative of, well, Congress is inert, Congress is gridlocked, and these are emergency social and economic justice issues. So do you see any role for the courts here? Maybe we'll start with you, Professor Mahoney,
Yes.
or Professor Epstein, however you like. Well, let's go to Professor Julia.
A lot going on. So there's the First Amendment. Sean is our First Amendment expert, I think, on this panel. I mentioned the First Amendment issues with respect to regulation of marketing claims. There are a lot of marketing claims that tell us if we buy things, we'll be respected, beautiful, et cetera, et cetera. A lot of these claims, no one thinks that the marketing claims are necessarily true, but the ones that show up in environmental and sustainability and so forth and so on and so forth seem to many to be especially exaggerated, even untruthful. And there certainly has been a push to have restrictions on what sorts of claims companies can make to get consumers to buy their products. And there will be, I think, some pretty serious First Amendment issues
with respect to that. In addition, there are a lot of growing issues about compelled speech, which Sean is, I think, writing on, and compelled speech issues, particularly with respect to proposed regulations. There are questions about agencies overstepping their bounds. The SEC's proposed climate disclosure regulation can be attacked on a number of grounds, including compelled speech, but it can certainly be attacked on the grounds the SEC is out of its lane. The SEC's statutes, one can argue, do not give it the authority. The statutes passed by Congress do not give the SEC this authority. The SEC is, in effect, has gone rogue, one can argue, and is behaving, doing things that the EPA is supposed to be doing, or Congress is supposed to be doing. So I think we will see a number of discussions on that. Antitrust has already come up. The questions about antitrust challenges, state AGs, the private plaintiffs' bar, and so forth. Federal, the regulators can certainly attack or may have concerns about antitrust violations that result from ESG initiatives, particularly these industry-wide standards.
Just to give a plug to this afternoon session, Professor Mark Kubish has a paper which he calls ESG Public Pensions and Compelled Speech, which essentially is dealing with exactly the same issues that Julia mentioned. The origin of this, I think, goes back to some of the labor cases, not only Janus, but Quinn before it, in what you see is the way in which these people work stuff is they create you as an employee solely for the purpose of collective bargaining, an employee of the state, and then announce essentially that they could exact fees from you, even if you're taking care of your own children, you are now an employee of the state. And that has led to it. So I think there are two things to be said. I think one is that the breach of fiduciary duty claims and the compelled speech are essentially both the same type of thing. One emphasis is the talk and the other is the transfer of wealth between parties. And I think both are going to be viable. As a prediction, I think the 6 conservative judges on this one will be as one and will reject this kind of motion. I think that 2 of the left judges will go the other way surely, just out of reflex habit. That would be Justice Sotomayor and Justice Jackson. Kagan is a much more interesting case, I think, because she always used to attend Federalist Society conversations when she was the dean at Harvard and when she was a professor at Chicago. And I think that she may well see that this is, in fact, an enormous wealth grab, enormous speech grab, and do it. But I do think that by the time it reaches to the Supreme Court, these programs will be on the defensive. Just as a general matter, and I'll ask everybody for their opinion, my view is that the social status of ESG is a rising movement, which I would have said was the case a year or 18 months ago. I don't see that as it anymore. I think, in fact, given the financial reports, the dissatisfaction, and all the rest of it, I actually think that it's now on the defensive. And it may continue to grow, but at a slower rate. And I also think that it's going to start to reverse itself. Is that a prediction that everybody shares? It doesn't share.
Yeah, so I think, look, I think that why did it rise in popularity the way it did? Look, I'll give you my impression, which is one, managers kind of like having more discretion to do what they want and not have, they can say, I'm doing this because it's good. It's not showing up in returns just yet, but don't worry about it. So they like it. Investment companies and complexes that are selling these products, they like it because it's another thing that they can brand and try to get investors to give them their money to manage. So they liked it. And frankly, the markets were, we had a 10-year bull run. So everything was basically going fine. And when everything's basically going fine, it's time to do some fun things at the margins, right? We might as well push the envelope a little bit. So that's honestly my view on why this took off when it did. And, I think probably some general dissatisfaction with an impression, at least in some circles, that government wasn't doing some of the things that folks wanted it to be doing, right? So you put all those things together into a pot, and it should be no surprise at all that this was viewed as something that everybody could get behind, right? The companies liked it, the managers liked it, and the investors, everything was going up, so who cares, why not? I think I agree with you, Richard, that a lot of those things, some of those trends are reversing now. The market has not been on a bull run of late. I don't know if any of you guys have noticed that, but I certainly have.
532 today.
Yeah. Okay, good. So we've got this pushback, right? We had that business roundtable. You mentioned, Sean, the Friedman editorial or whatever it was in the 70s. And then I remember it was like 2019, all of a sudden all these companies signed on to the Business Roundtable that they're going to, do good. I think basically all of the big companies have walked that back now, right? They've said, well, actually really our job is to make money. So, this goes a little bit to my quip before, which is like, this was a really big problem for like 15 minutes. And for a variety of reasons, it seems to be, I think, maybe again, this is my Pollyanna, like basically going back to normal, probably for the most part.
Can I ask a question, Adriana, of you? So I agree with all the stuff that you said, and I also agree with your perspective that this is a thing that the market should solve and might be solving and might have solved, is what you just said, I think. And it seems to me that the mechanisms that, are, to answer Christina's question, intra-corporate mechanisms or market mechanisms are superior to a court solving these questions, it seems to me. But there might be aspects that courts need to hear anyway. But it didn't, the reason that I started my remarks in the way that I did is that it strikes me that all this stuff is in the academic literature again, right?
Totally.
And you mentioned Lucian's defenses of the Friedman position, but there are a lot of respected academics arguing the other side, and there's a lot of academic literature on the other side. And so I just, that to me is sociologically interesting, right? Because it seems to me the argument was decisively won in the 30s and then again in the 70s by the same side.
You win it again.
Right. It reminds me of a lot, well, I won't say. So anyway, I guess my question, Adriana, is why is that? So you say, and I kind of agree, that this is a problem that was a problem for 15 minutes and now it's either going away or gone away. But are the academics the last ones to hear about it?
Yes. I don't know how many academics you know, Sean, but the idea that a shiny topic that lets people substitute their policy preferences for other people's does actually sound like a catnip to a lot of academics. And look, we do corporate and security stuff. I get excited about things that are good for market functioning, but it turns out that not all law professors do. And some get more excited.
Including not all securities law.
No, exactly. It turns out.
Under generalization of the century.
I try.
Try to be reasonable. It doesn't work.
So look, is it shocking to me that folks, even corporate and securities law professors, would like to latch on to something that lets them substitute their policy preferences for others? No.
No,
On that note, do we have questions from the audience? There's a mic there if you want to go, or we can pass around, or however you want to.
My name is Jonathan Garcia from Stanford Innovation Fellowship. My question to the whole panel, but particularly Professor Epstein, is there any way to regulate a direct beneficiary for ESG funds?
To regulate what?
A direct beneficiary, you used that term earlier, for ESG funds?
Well, I think what I was trying to say was that if you are somebody who is in fact a so-called person who is a beneficiary, technically they're your trustee, the standard action of a suit for breach of fiduciary duty brought in an individual in derivative capacity seems to me to be something that ought to be allowed in these particular cases. The battle is going to be as to whether or not ESG affords a sufficient social justification that somebody's prepared to say, even though there's a loss to the company, we are so confident that the external gains dwarf that particular loss that we're not going to disallow it. I think what's happened now is that people just don't believe those sort of grandiose claims that you can do this, and so I think that these suits are going to gain in strength.
I don't know where he went, Richard. You're looking at me.
Okay, anyhow.
Oh, okay, there he is.
Okay, I saw him, but so I think in effect that these suits are going to gain in power. That is, what's happened is the relative collapse in returns in this industry and the general collapse in the market is such that people have an anxiety level, which means they're going to be, as Adriana said, less willing to play around with various kinds of diversions. So that would just be my answer.
Oh, okay. I'm Jason Johnston from the University of Virginia Law School. And I have a compliment, a comment, and a question. First, a compliment. This has really been a great panel. You all have really unpacked and illuminated the different kinds of issues that come up around this whole ESG thing. The comment is this ESG thing is a very small part of the politicization of the economy. There would be no Tesla were it not for the government subsidies that Tesla got. Within 2 or 3 years, General Motors and probably all the other American auto companies will be bankrupt. The government will bail them out, and they will effectively become even more nationalized than they've become. Right now, over the last 6 months, European governments have nationalized most of their energy sector in order to protect consumers, supposedly, from the horrible mistakes those governments have made in the past with their completely idiotic approaches to decarbonization. So ESG is important, but I think just a small part of this overall theme of the politicization of the economy. And here's the question, and this is kind of embarrassing because I have money in these retirement funds too, and I'm aware that BlackRock and Vanguard at different times said they were committed to net zero, which again is a completely unobtainable and completely stupid and idiotic idea. Now, why would they have been, and I think that that was a commitment that applied to all their funds, not just the actively managed funds, but also the index funds. Now, I invested and have been invested in some index funds under the assumption they were index funds, not under the assumption the index funds were being managed to accomplish net zero goals. So to the extent we have people who've invested being told this is what this fund does, and then the people who run the whole suite of funds say we have an overall net zero goal, why isn't that, it's got to be a breach of their fiduciary duty, doesn't it?
It's even
I
worse.
mean, wasn't the original, they advertised the fund as one thing, they've said the fund does one thing, and here's the problem, and you all alluded to this, these are these, retirement funds. You can't just, you have a limited set of options, you can't just pull your money in and out, it's not like other investments I have. You're committed. There's a very high cost to moving the money. In some cases, people can't move the money, and that seems to me to be the real problem here. All of the other stuff you talked about, there's a kind of a Friedman-esque type, response, a kind of market response, but not this, because BlackRock and Vanguard, they're not ordinary market players. This is not free competition. They're huge, huge owners of these shares. When the two of them say something to a company, that's different, okay? Now we're far, far, far from a world, I don't even know if Milton Friedman would have anticipated this world, but it's not the world he was talking about, where you have institutional investors with shareholdings and this kind of power, this kind of market power, to literally, if they colluded, they could just completely control and change prices. And a final comment is, unremarked in this debate has been that people like Fink and say the biggest 50 or 100 people who show up at Davos, they are heavily invested in what they call the new world. They're heavily invested in these new technologies. It is strongly in their economic interest to destroy the old technologies at any cost, because they are looking at potentially, this is what they want, they're looking at potentially making trillions of dollars, not billions of dollars, trillions. And that's what's driving this entire thing. And when you look at the Democrat Party, there are 20 or 30 people who pretty much drive the Democrat Party agenda. Now, there's some Republican donors too, but it's less concentrated. Anyway, that's neither here nor there. My real question is, gosh, how could these guys, this is the court thing, how could these guys get away with this?
Hey, look, the one-sentence answer is the controversial case is where you have an explicit change of policy, which is publicly announced and supported by a supermajority vote. Do the dissenters have the right to say you can't do this to us? But this is a case in which it's done in secret. Nobody has heard about it. And so at that particular point, it seems to me that this is so far removed from a difficult case that it's a summary judgment case, and the only thing left is figuring out a remedy. First remedy is you undo the policy. Second remedy is you bankrupt all the guys who implemented it. And the third remedy is there's still going to be a gap that you can't fix. I think that's the way in which it goes. Sean spends all his time worrying about this. Have I stated the law
Yeah,
correctly?
I think so. Yeah.
Amazingly enough.
Yeah, I would have thought it was a clear case also.
And to be clear, when I mention woke capitalism, I mean something way beyond ESG. ESG investing is often the mechanism, right? It's one of the most potent mechanisms. So when we look at the problem of corporatism, we see corporations making decisions that are designed to curry favor with or avoid penalty from government, and they pledge to pursue long-term benefits for society as a whole or for the planet, and not, quote, just profits that will inure to the benefit of their shareholders. That's the game. And the concern is that then the government and for-profit businesses are, in effect, making decisions that most voters think should be made through the democratic process, and they're sidestepping it. And I think that immediately sums up the problem. So what to do about it? One thing is, of course, to look very carefully at the mechanisms and figure out where there might be vulnerabilities. If one is concerned about this kind of cronyism and corporatism, and I certainly am, as I mentioned at the very beginning, this is part of what animated the American Revolution, and it was very much on the minds of the drafters and ratifiers of the Constitution, and it comes up again and again and again throughout American history. And it's never been an easy set of problems to ameliorate, much less solve. In fact, we haven't solved them, obviously. But we can ameliorate them. So the antitrust considerations with respect to industry-wide ESG initiatives are, I think, very, very important. The question of fiduciary duty, particularly with respect to the Department of Labor's proposed rules, I think they're going to be quite vulnerable on the grounds that they are, I would say, in grave tension with and probably in stark opposition to the actual text of the statute. I think courts may end up telling the Department of Labor that they can't do this. They'll need to go to Congress if they wish to pursue, to give their imprimatur to ESG investing being a quote, tiebreaker. So I would be surprised if courts are willing to sustain these proposed DOL regulations. The SEC's climate change rules, we don't have the final version, obviously, but they are certainly vulnerable to attack on First Amendment grounds and on grounds that the SEC is, as I mentioned, going outside its jurisdiction. With respect to the so-called Big Three, you're right. They are indeed a formidable and very powerful group, and yet, we don't know how vulnerable they are to competition. I don't know whether or not it has to be the case that someone has thought about competing with the Big Three, and we may yet see that.
Yeah,
and we have seen a little bit of that, right, with Peter Thiel and others.
Strive
yes?
Capital, is that
yes.
the one you're thinking of?
Yeah.
Exactly.
Another
Strive
classmate
Capital.
of mine.
Yeah. So.
Uh-huh. Okay, I'll let.
Anyway.
One comment on the energy policy, which I think is interesting.
On the energy policy?
Well, I mean, it is suicidal, but the argument that we see is they're fossil fuels which have all sorts of negative externalities, and this amazing new technology, which somehow always works and has no externalities, known as wind and solar. The interesting feature about this is there is now very fierce resistance to the deployment of these particular sites in the neighborhoods in which they are to be deployed. And it is not, and this is why they will work, this is not the fossil fuel energy getting involved in this. If they were to do it explicitly, they would be subject to huge kinds of political complications. It's essentially, it's moms and dads sitting at the kitchen table organizing the neighbors and saying, well, you know, this thing is going to make the following amount of noise, this is going to kill that much of arable land. And I think, in effect, if I were to try and structure the strong opposition to the renewable kick, is I would essentially spend most of my time indicating that it's just a different set of externalities. It's not no set of externalities at all, and that no matter how do we measure them, they're going to be very large, and the following truth takes place. Fossil fuel, given the technology, is amenable to more rapid improvements in technology than is solar and wind, which are going to run into serious natural limitations onto how much you could do as a matter of basic laws of physics.
I made that whole point in a book I published.
What?
I made all those points in a book I published
and
last
so
year.
far, well, God bless you is all I can say. This stuff, as far as I'm concerned, is a racket of absolutely profound proportions. And so since I've said that, I mean, the amount of abuse you take for saying
Trillions
this.
of dollars.
But
It's
trillions of dollars. This is the biggest mistake in the history of the world. Well, we've got COVID as a competitor,
That's true.
right? And it's the same kind of crap.
Yep, absolutely.
Essentially, it's authoritarian people at the center defining what is information and misinformation, and taking vaccines, which turn out to be probably the most dangerous things ever devised by man, and treating them as something which you have to take for your own health, because we know what's better for you. Anyhow.
As they say, you're preaching to the choir.
Well, I know you're a very small choir, unfortunately.
I have learned that. I am a very small choir.
My name is Paul Mahoney from the University of Virginia. Just a comment that I'd be interested in your reactions. So as our panelists pointed out, in the 1930s, we have managers arguing, hey, we can take shareholder money and use it for purposes that are not the shareholders' purposes because, you know, we're good people and trust us, and they lose that debate. In the 1970s, managers are making the argument, we can take the shareholder money, et cetera. They lose that debate. And there was seemingly a sense of surprise that, wow, this debate is reappearing. And I guess I'm not very surprised by it. And the reason is this. Going back to Sam Bankman-Fried, he believed he could take investor money and hand it over to better purposes. And interestingly, the U.S. Attorney for the Southern District did not say, I'm sorry, Sam, you've lost the intellectual debate. He brought him back to the United States in shackles, which is a little bit of a different thing. And it seems to me that given the amount of money available, of investor money available to be diverted, until there are serious fiduciary duty suits in which some executives of money management firms or operating companies lose significant personal amounts of money, this is just going to keep happening.
I mean, is the point that either we hold them personally liable or it's a useless endeavor? That sounds right.
Yeah, so I totally agree. These are, this is the classic problem that we deal with in corporate and investment law, which is, I don't want to be personally running the company as an investor. Like, that's why I hire managers to exercise their business judgment, right? And then we think, as a general matter, right, this is like Corporations 101, like, courts are not very well positioned to know how to run companies either, and so we have strong deference towards managers, right? That's the business judgment rule. But of course, sometimes managers act disloyally, or sometimes they act outside of the bounds of what they're supposed to do. And it's just like a really hard problem to know when that's happening and when that isn't. And I certainly don't want to sign on to a theory that says, no, we're going to have courts supervise every single company, every single decision that they make, or regulators for that matter. Like, that sounds like a terrible idea, right?
It is a terrible
idea. But of course we also want to go after the ones that are not doing their job properly. So this is just like the same problem all over again. And then in the investment management context, again, same thing. The reason I'm invested in a mutual fund is because I don't want to have to pick and choose every company, which one's a good investment option and which one's a bad one. And I certainly don't want to have to vote all of the shares, but there's like on average, 5 to 10 votes at every company, every proxy season. So if I have 500 companies in my well-diversified portfolio, you seriously expect me to read all of those proxy statements?
I expect.
Well,
Anybody else?
I hate to break it to you, Richard, but I don't. And I don't want to either, because I have a job, right? And so the whole point is I hire somebody else to do it and to exercise their judgment on my behalf. But again, not all fiduciaries are loyal, right? And not all of them are diligent. And so I guess all I'm saying is I agree with you. And I don't think I'm saying anything you wouldn't agree with either, Paul, which is like, this is a really hard thing to police, and we've been trying to police it for 100 years, and I don't know that we have the answer, but...
I disagree.
Oh, okay.
I don't think it's as hard as you make it out to be at the extreme. So let me give you the case of water law, which is the same problem. There are all sorts of very complicated questions about how you allocate water amongst various riparian and in-stream users, and you have to have often some kind of authority that pushes it one way or another. But there is the same principle is if these guys, instead of trying to figure out how it is they satisfy the multiple claims of their various beneficiaries, decide to divert the river to somebody else outside the stream, that's a per se violation. And I think the corporation version of that is if you're trying to figure out how you jiggle multiple imponderables, you're going to be protected under the business judgment rule. But if you make a wholesale commitment to giving the money out to somebody else who is not one of your intended beneficiaries, that's a per se violation, and there you go back to the fair value rule.
But the rhetorical trick there, Richard, is that they can say, this is what Adriana called values-based ESG.
Yeah, I understand
right?
they can say it, but...
And then courts will say, oh, deference to business
look, I
judgment.
mean, okay, now this gets me to something else. If the courts are going to play the deferential line whenever something becomes very difficult, the game is in fact going to be over. This is an acute version of Chevronitis, a disease which was foisted upon us by Justice Stevens in a very bad moment. But I think if you start looking at other areas in which, say, for patent disputes and things like that, if in fact you tell courts you have to do something, this is what happens. Your IQ goes from minus points, which is what you have under Chevron. It pays me to be as stupid as I possibly can because I can duck my responsibility. And now, in effect, when you have to actually do something, all of a sudden the IQs are going to rise because lawyers are going to actually present arguments on the merits, and you will improve the performance. So one of the reasons why you want a major questions doctrine or just standard scrutiny is you want to take judges out of their judicial torpor and put them to work. If they, in fact, know that they have to make the decision on the merits, some of them are going to rise to the challenge. The ability of a judge is not exogenous and independent of the legal rules under which they work. If we expect nothing of them under the deference rule, that's exactly what we will get, intellectual borscht that you don't want to drink. But if you expect more of them and they rise to the challenge, then I think the performance levels would be higher. And I'm not talking here about cases that are extraordinarily difficult. My view about everything like this is you do not want to start this discussion. Here I disagree with, I think, everybody. You don't want to start the discussion with an interesting case which is right at the balance. What you want to do is to ask yourself, is there low-hanging fruit? Go after that, and there's a lot in this particular area. And if it turns out you can't get every other kind of thing, the incentive effect is going to move the whole distribution in a federal way. So do what you can do with confidence and then take it one step from there. Always begin an incremental program at the easiest point for intervention, not at the hardest point for intervention. And I think you'll come off a lot better in the way in which it's done. And when you start looking at these Chevron cases, for example, on pipelines and so forth, the level of judicial stupidity that manifests itself under a deferential standard is simply legendary. And you cannot abide that. If we have a judiciary which thinks it's going to basically work with a frontal lobotomy every time it hears a case, then we are doomed because there's no ability at anywhere in the system for anybody to check anything. And so I think, in effect, we really have to take the following line. Yeah, we know there's the occasional marginal case, but the test that we have done between conflicted situations and business judgment rule, that's a rule that's worth defending with your life, even though it turns out there's some cases on the border. And so I think in that sense, we do not want to have a dose of sort of general intellectual ennui and skepticism about the capacities of the legal system to function.
So can I just add, I think this is these difficulties have showcased the importance of taking a very, very careful look at fiduciary duties. I mentioned earlier the fact that some state legislatures are doing exactly that, looking at clarifying the corporate fiduciary standards and maybe even making them a little bit tougher. Many of the assets that we've been discussing, the fiduciaries are held to a trust standard, which is tougher than the corporate standard. So there is some daylight between the trust standard. In particular, ERISA made it very clear that that there would be a trust version of fiduciary duty on pension, most pension plan fiduciaries. Perhaps there should be less daylight. In addition, we need to look at the difference between the duty of loyalty and the duty of care. It may be that there are a lot of duty of loyalty violations going on, because there are assets being actually diverted. In general, when assets are diverted, it is a duty of loyalty issue, and there is not the kind of deference that Richard has just been discussing. When there has been an asset dissipation, waste, the duty of care has been implicated, and their courts have tended to be much more deferential. But one thing we have seen again and again with courts deciding fiduciary duty cases is that they are not deferential at times when there are real possibilities of infidelity on the part of the agents. The corporate takeover context, change in control, is the most high-profile example of that. And so I would simply say, hold on, let's look at what state legislatures do. Let's look at what state courts do, particularly the Delaware courts. We may well see some changes in the law and some doctrinal innovations.
Yeah, and I would just say, if I had to pick somebody to substitute their business judgment for that of a court, or for that of a company, I think I would pick like Katie McCormick or Lori Will. I mean, the Chancery Court, I think I'd trust a lot more than, pick your favorite district court. In the ERISA context, it's hard. Yeah, the Delaware Chancery, look, they've got pretty good business judgment of their own. Maybe you disagree.
No, I don't disagree. My problem with the Douglas Champion is this following. Highly specialized court can flip much more rapidly than a diffuse state. So when they're good, they're very, very good, but God forbid if they should ever turn bad, right?
Let's hope that doesn't happen.
Then it's a disaster. So I would hedge my bet and want to go a little bit both ways.
Ben Johnson, Penn State Law. I had a question for Professor Robertson on the marketing angle, right? So I think there's a pretty easy sort of marketing story for like actively managed funds, for example. Like, hey, I don't particularly care about ESG, but if you're willing to pay me an extra 100 basis points to like put stuff in green companies, I'm happy to take your money, right? Sure. So like, and if I put that advertising out there, that seems like marketing totally fine, right? But in a world where I'm trying to basically sell people that I share your values, right? I'm actually selling something different, right? I'm trying to make a claim that's not about like how great my product is or whatever else. I'm trying to say, come take a pay cut to work for my company because I believe this stuff so much that I'm willing to do X, Y, and Z, right? So I can tell you a profit maximization story for why a $50,000 donation to the Human Rights Campaign, which helps me hire a bunch of Berkeley grads because I share, they share my values or I share their values or whatever else. I can understand that as a profit maximizing thing. But the moment I announce I'm doing this for profit maximization is the moment this ceases to be valuable, right? Because really what I'm telling you is, hey, you guys are a bunch of suckers, and I can spend $50,000 and I can hire a bunch of you for a lot less money, and I'm playing you for suckers, and that's the truth, right? So that doesn't sound like marketing to me, that sounds like fraud, right? So I'm wondering, like, where is the line here between these easy cases where it's like, hey, listen, I know there's a market out there for people who want to spend this stuff, and I'll just like put the product out there. But there's another thing where I think, which a lot more of this is where people are trying to change, like, what's the product value of Hellman's mayonnaise or whatever else? Like, where it starts to be much more about this idea that we're trying to, like, present, like, a false, statement about who we are and what I am and what I do in a way to basically expropriate money from people. And that strikes me as, like, not defensible under traditional marketing.
Mm-hmm. Yeah, so, like, I'm going to be very clear that, like, fraud is illegal.
Oh.
And whether you're defrauding people on the basis of ESG or anything else, like, I don't think there's an ESG get-out-of-jail-free card for fraud. And if there is, there certainly shouldn't be one, right? Because fraud is bad. I'm gonna make that statement. There's also puffery, right? And I think we as a society have agreed that some amount of puffery, like, I don't know about you, but it turns out that, like, maybe not every student I've written a letter of recommendation for is, like, the best student I've ever had, right?
Only Guido Calabrese.
But I think we also know that, like, readers also kind of know that, and this is how puffery works, right? So I guess I'm a little, taking a step back. This goes a little to the question of how much of this is new and how much of this is just like garden variety statements that companies make. And whether it's a statement about their commitment to DEI or it's the statement about how this is like so delicious, it's the best cheeseburger you've ever had, like, I don't know. At a certain point it crosses the line into fraud and at a certain point it doesn't. And then of course there's the question, I think you can draw an analogy, sticking with my cheeseburgers, even though I don't eat cheeseburgers for the time being. You can simultaneously try to market your cheeseburgers being delicious and juicy and also being low fat and healthy. Like, at a certain point that it's hard to believe both of those two things at the same time, right? And similarly, it might be hard to believe at the same time that we're doing this because it's good for our bottom line and also we're doing this because we really, really, really believe it. At a certain point, the tension there becomes untenable and your marketing strategy breaks down. But I guess I just don't know what's special about that with respect to ESG versus, like, cheeseburgers.
Look, jury questions, you need juries or triers of fact to make hard cases at the margin. And that's what you're pointing to. The line between fraud and puffery at the extremes is quite clear, just like the line between day and night is very clear. But you get twilight. And I think I'm going to say it again. We should never get obsessed by ambiguities that pervade 1% of the cases if we could sort out the other 98 or 99% with a relative degree of confidence. And that's the danger of teaching with the Socratic method if you're not careful, is you start to think that the world is only filled up with cases that are going to require an appellate court to get a divided decision. Many cases are easy, and so everybody should repeat after me. In a world in which people operate badly, there are many cases of pronounced fraud that are easy to convict if you'd only had the courage to go after them. Oh, Mr. Pierce.
All right, so we have perfect timing. We have 5 minutes left for this last question.
Well, he's
so.
going to take all the time.
Dick
Yep, all the
Pierce
time.
from George Washington Law School. I'm really uncomfortable taking the position of Pollyanna, but this panel is forcing me to take that position. You really have caused me to enter the day feeling better about the world than I did before. The initial speakers did a good job of saying, well, you know, this is not anything new. It's just a new manifestation of something we've had forever. And it all sounded entirely plausible and right to me, except it seemed incomplete. And then Richard completed the picture by adding something that is always there and really has to be always there, boundaries of some sort, legal boundaries, okay, it becomes pretty quickly apparent that every boundary consists of a combination of an institution, substantive rules, and procedural rules. And it's very easy to demonstrate that every one of those boundaries is horribly flawed and imperfect. But what I hear happening is a whole bunch of very smart people debating exactly which of those boundaries is less imperfect. And as long as we've got debates like that, then I really do walk away from this presentation saying, we're in pretty good shape. The world, I think the world looks pretty good down the road.
Look, I have just one comment. I did write a book called Simple Rules for a Complex World, right? And it's not a book about a simpleton. It's a rule which basically says if you get the first cut right, you solve a vast number of the cases. But it turns out sooner or later when things get scrambled up, there will be a subset of cases that are very difficult for which you then have to shift to some kind of a rule of reason. The issue that you want to do is to make sure you don't start with rule of reasons, you start with bright lines, and then when they break down is when you start moving the other way. But you never want to put yourself into this position where everything is always a question of balancing 16 different factors, and there's never such a thing as a clear case. And so my view is that what we have to remember is if you're an enforcement agency, start with the easy stuff, and then by increments proceed until it turns out it's just too costly to enforce. And we can go after some of the really blatant objections that people have described. I mean, when people sort of make secret investments based on ESG and don't disclose it to the world, that's not a really difficult situation, is it? I mean, is there somebody here who says, oh my God? Well, go after that, and well, you've got CalPERS. I mean, that's a small fish or a big fish? It's a big fish. And they should be very vulnerable for the kinds of stuff that they play. And then once they do that, maybe they will then own up and have two separate funds, and we'll see the progression that we mentioned earlier. And so I agree with you, we can be optimistic. The problem is the people in this room are not a random subset of the people in the academic academy.
Well, I spent yesterday with the Center for Progressive Reform, and it's fair to say that the debates about these subjects tended to go generally in a somewhat different direction. But they were similar in the sense that they were people trying to recognizing that they're dealing with choices among highly imperfect alternative institutional arrangements, and do your best to come up with the least imperfect. And Richard and I, every few years, I love these occasions. We have these big debates where we each come in with these very strongly held views. And what's very easy to do, and I think each of us do quite well, is show that there are massive flaws in the other person's views. But coming up with the right, that's hard business, but I'm sure happy to see lots of smart people engaged in trying to do it.
The ultimate debate is what is the size of the penumbra? And if you think it's very large, the world is doomed. If you think it's relatively small, we can get along having to make sure that there are going to be a fair number of important cases that we'll get wrong. And I think that's the definition that we want to accept, rather than the one that imperfections is such that every case is a crapshoot.
Well, that's a nice point of agreement.
Okay.
It sounds like a nice way to end the panel also. Please join me in thanking the panelists for their excellent and astute remarks.
Always. Great to see you. No, I got in late last night. I taught you.